Good afternoon and welcome colleagues, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. We are continuing our pre-study on Bill C23, an act to amend the Canada Elections Act and other acts. This bill proposes amendments to numerous aspects of Canada's electoral law, along with related amendments to the Telecommunications Act, the Electoral Boundaries Readjustment Act, and the Director of Public Prosecutions Act, among other acts. The bill is currently being studied by the House of Commons Standing Committee on Procedure and House Affairs, which has heard from a number of witnesses on certain elements of the bill. Our task as a committee is to conduct public hearings on the subject matter of the bill, which will allow us to report on some of our findings prior to its introduction in the Senate. And for our first witness panel this afternoon, quite pleased to welcome to the committee from Elections Canada, Marc Mayrand, the Chief Electoral Officer of Canada, and Stéphane Perreault, Deputy Chief Electoral Officer, Legal Services, Compliance and Investigation. Welcome, gentlemen, and Mr. Mayrand, you have some opening comments?
Yes.
Please.
Thank you. Merci, Monsieur le Président.
Thank you, Mr. Chair. It's a pleasure to appear today as part of the pre-study of Bill C23. Because it's a preliminary study, I think that it would be useful to take a step back and provide you with my perspective on the key objectives underlying our electoral process, as well as the important challenges we're currently facing. My hope is that this will assist the committee in assessing whether Bill C23 helps address these challenges. While I intend to highlight certain elements of the bill in my remarks, I do not plan to enter into a detailed review of the various changes I recommend. I brought a table indicating what those changes are and would be happy to discuss them after my introductory remarks if the committee so wishes. The legal framework governing Canadian elections is a reflection of certain key values or fundamental democratic objectives, namely accessibility, fairness, and trust. In modernizing the electoral process, it is useful to consider these objectives. By accessibility, I refer both to the legal right to vote and to be a candidate in federal elections, as well as to the actual means of exercising that right. Under our Constitution, every Canadian citizen is guaranteed the right to vote. However, that right is made meaningful only to the extent that there is a proper legal and operational system in place allowing it to be exercised. Over the years, not only has the right to vote expanded, but barriers have been removed by providing more options for voters with the aim of giving all Canadians, no matter their particular circumstances in life, a true opportunity to exercise their right to vote. While barriers do remain, in particular for electors with disabilities, our constitutional obligation is to strive to reduce those barriers. It is also our international commitment under the United Nations Convention on the Rights of Persons with Disabilities. A second fundamental objective of our electoral system is fairness. By this, I mean a system where those who compete for electoral success do so under conditions of relative equality. The expression level playing field is often used by the courts and experts to describe our regime of limits on elections expenses, which serves to ensure that elections are not dominated by those with access to greater resources. Limits on contributions in conjunction with public financing similarly contribute to the level playing field. Fairness also means a process for administering elections that is free from partisan bias or the appearance of it. In this regard, fairness is also linked to the third objective, which is trust. The importance of preserving trust in the integrity of the electoral process is reflected in the various procedural safeguards that protect against fraud in the electoral process and that ensure the transparency and reliability of results. Trust also depends on timely and effective enforcement mechanisms that promote compliance with the rules and address cases of non-compliance when they arise. In our system, enforcement is primarily the role of the Commissioner of Canada Elections. Given these three objectives, accessibility, fairness, and trust, what then are the main challenges facing our electoral democracy? In my view, The single most important challenge facing our democracy today is the decline in voter participation. Declining turnout is far from unique to Canada and is not a recent phenomenon. But our participation rate is one of the lowest amongst advanced democracies. The decline in voter participation is mainly driven by the decline in youth turnout beginning in the 1970s. We know from our research that young adults who do not vote in their first election tend to also not vote as they get older. This is why civic education programs are so important. There are, however, encouraging signs. From 2004 to 2011, first-time turnout has leveled off and is showing signs of increasing. At the same time, I can say there are nevertheless electors for whom participation is a challenge. With a rapidly aging population, this is increasingly true of seniors. They tend to be less mobile, have more difficulty with the voter identification requirements, in particularly the requirement to prove their address. This is why at the last general election, I authorized the use of the voter information card, along with another piece of ID, at certain voting locations, namely in seniors' homes, student residences, and on reserves. Building on our experience of the last election and that of other jurisdictions, and also in consultation with political parties, we have been planning to allow the use of the VIC as proof of address, along with another piece of ID for all electors in 2015. This would serve to remove barriers as well as to reduce the recourse to vouching, which has proven complex for election workers to administer. A second important problem for our electoral system arises from the complexity of the rules. Overly complex rules can create barriers to participation or situations of non-compliance that undermine trust in the integrity of elections. This is a problem with respect to the voting procedures, which are administered by some 200,000 ordinary Canadians with limited training and often no prior experience. Our voting process was designed initially and appears simple at the outset, but what has happened since 2007 has made it much more challenging for poll workers. Complexity also presents a challenge with respect to political financing. Again, this is a situation where the rules have become considerably more complex in recent years through successive reforms. And here, the regime relies largely on the work of volunteers serving as official agents for candidates. They are responsible for ensuring that the campaign respects all the requirements of the Act, and they are ultimately required to account. It has become increasingly difficult for these volunteers to understand and comply with the regulatory requirements. In my recommendations to Parliament, I have strived to identify ways of reducing the regulatory burden and of improving the simplicity and clarity of the rules for the benefit of all participants. This remains one of my concerns. Finally, a third challenge we face is the lack of adequate compliance and enforcement mechanisms to ensure timely and effective responsive to contraventions of the Elections Act. There is a very heavy and time-consuming approach that is in place. It is ill-suited to the majority of cases of non-compliance that would be more effectively addressed by way of administrative sanctions. In cases that do not warrant an investigation, experience has shown the Commissioner lacks the proper tools to conduct his investigations in an effective and timely manner. Moreover, the fines are not sufficiently severe.
In reviewing the bill, I would invite this committee to consider the impact of this provision on the challenges that I've identified, as well as on the main objectives of our electoral framework. Some elements of Bill C23 will help address some of our challenges and support the key objectives. The addition of one more advanced voting day will provide more convenience for Canadians casting a ballot. I also welcome the proposed increase of the fines. More importantly, I believe that the introduction of administrative sanctions, for instance, of overspending by political parties or candidates, is a positive development. It is a move away from the traditional model of criminal sanction, and I certainly hope that it will serve as a precedent for future reforms. Bill C23 also includes a number of reforms which, while positive, require amendment in order to produce their intended benefits. This is the case in particular with the proposed regime for guidelines and written opinions. These could be extremely useful tools, but are unworkable as provided for by Bill C23. Changes are needed to allow rulings to be made in a reasonable time frame. Others are also needed to prevent partisan abuses that could result in if political parties are allowed to require formal rulings on matters that are under investigation or pending before the courts. In addition, if rulings are to be legally binding on the Chief Electoral Officer and the Commissioner, they should be equally binding on the external party compliance auditors. The regime for voter contact services must also be improved. In order to be useful, the regime must not only require information on service providers, clients, and scripts, but must also require the retention and production of telephone numbers that are called. As well, calls made for political parties and candidates by their own staff or volunteers should not be exempted from the disclosure requirements. As it stands, it seems that the proposed regime would increase the regulatory burden on political parties and service providers without significantly improving the integrity of the process and the ability to conduct timely investigation. Finally, a number of aspects to Bill C23 are deeply concerning, and I feel it is my duty as Chief Electoral Officer to inform Parliament of those concerns in the clearest possible terms. I would like to focus on 5 particular. The first of these are the proposed restriction on voter identification, namely the removal of vouching for electors who cannot provide documentary proof of identity and address, as well as the prohibition on using the VIC along with another piece of ID. It has been argued that all electors should have ID documents to vote, but this is not the problem. The problem for a significant number of Canadians is to have documents proving their current address. The notion that all Canadians have in their possession documents establishing not only their identity but also their current residential address is simply wrong and not borne out by experience. For example, seniors living in long-term care facilities often do not have driver's licenses, hydro bills, or even health cards, which are typically kept by their children or facility administrators. Young Canadians commonly live at home or as students move frequently. They often do not have any documents to prove their current residential address. Overall, we estimate that approximately 120,000 active voters rely on vouching, and we can expect that a large proportion of them will not be able to vote under the proposed rules. Just as importantly, in the absence of any credible indication that vouching or the VIC are used fraudulently, their removal would compromise accessibility without in any way enhancing the integrity of the electoral process. We have not been able to find any other jurisdiction in Canada where a requirement to provide documentary proof of evidence to vote is not also accompanied by a safety net such as vouching or a statutory declaration.